Good afternoon. It's exactly 2 minutes past 3 o'clock. And as we said, we want to stick to our time. We said we're going to start this at 3 p.m. exactly. So I will go ahead and start the session. Distinguished members, I know we have some governing council members around, invited guests. You're all warmly welcome to CIRIP's membership engagement session. We are very grateful for your time this afternoon and for your participation. But before we proceed, I'd like us to take a word of prayer and then we continue. So let's pray. Our Heavenly Father, we thank you for bringing us together today and for the opportunity to meet as members of this beautiful institute that you have given us. We're grateful for life, for health, and for the work you have entrusted in our hands. As we begin this session, Lord, we ask for your guidance in all our discussions and our decisions. Grant us wisdom, clarity, and a spirit of integrity as we reflect on issues that are important to our profession and to the growth of our institute. May our deliberations be very fruitful, constructive, and beneficial to all. In Jesus' name, I have prayed. Amen. Can I hear your amen to know that you are with me?
Amen. Amen.
Thank you very much. Thank you very much. So my name is Petrina Kwe, and I am the Marketing and Corporate Affairs Manager and the Executive Secretary of CIRIP Ghana. This afternoon, it is my pleasure to host you on behalf of the President and the Governing Council members. I am not doing this alone. I'm doing it together with other management team. So quickly, I will go on to get the rest of the team on board and then we get the ball rolling. Now, as we are all aware, this session forms part of our ongoing membership engagement series. And I wish to know that this is the second CIRIP membership engagement session. I know some of you were able to join the first one, which was quite fruitful and very educative and enlightening, because that was the time most of us came to know about our institute and its new status. So as indicated in our publicity materials, this very session counts towards members' continuous professional development, that's the CPD. And before we get out of here, I'll share a link. We will all fill the link to indicate our willingness to count this as a CPD for us. Members are kindly also informed that the subject matter of this meeting, that is the Code of Ethics, can be found on our website. So you can go later to check it up, or you can also download it immediately as the speakers address the topic. Once again, thank you very much for joining us. We look forward to a very engaging and insightful session. Let me say that we will have a time for Q&A. So please get your questions ready, get your papers ready, as your papers and your pens ready as you write the thoughts that will come to mind. Not only Q&As, but also contributions that you think are meaningful to this engagement, to our afternoon engagement. So without talking further, I'd like to invite the CEO of CIRIP Ghana, Mr. George Owudu, to give us an opening remarks. CEO, please, if you are there, I yield my mic to you. Thank you.
Thank you very much, Patrina. And thank you, everyone, members of the Governing Council, our distinguished speakers, invited guests, members of the Institute, ladies and gentlemen, good afternoon, and a very warm welcome to this membership engagement session of the Chartered Institute of Restructuring and Insolvency Practitioners, Ghana. We truly appreciate you for taking time to join us today. Today's engagement is held under the theme, the CIRIP standard, ethics as the ultimate risk management tool in restructuring and insolvency in Ghana. This theme is both timely and strategic. As many of us appreciate, Ghana's insolvency and restructuring landscape has evolved significantly with the coming into being the Corporate Insolvency and Restructuring Act 2019, Act 1015, and the more recent one, which is the Chartered Institute of Restructuring and Insolvency Practitioners, Ghana, Act 2024, Act 1117. As queries set out in the Act 1117, the sources of this progressive legal framework rest fundamentally on the conduct, integrity, independence, and professionalism of those entrusted to administer the law. This is why the CIRIP Code of Professional Conduct and Ethics is not merely a comprehensive document, but a core pillar of risk management, public trust, and value preservation in insolvency practice. Under sections 3, 23, 27, and 36 of the Act 1117, the Institute is empowered to enforce ethical standards, monitor professional conduct, and work closely with the Office of the Registrar of Companies to ensure effective implementation. Ethical breaches carry clear consequences, which will include revocation of membership and public practice licenses. This underscores the seriousness with which ethics must be treated by every member. This session is intended to deepen our understanding of the CIRIP standards, highlight the fundamental principles underpinning our code, and demonstrate how ethical discipline serves as a preventative control across the insolvency life cycle, from appointment to close out of cases. We also expect today's discussion to make the code more practical and relatable for members. I encourage all members to engage actively, ask questions, reflect on how the standard we uphold today will shape not only our personal credibility, but also the reputation of CIRIP Ghana and the confidence of the public in our profession. As we look around to get the most competent resource to handle this topic, we found no other person in our jurisdiction than Mr. Andrew Akoto and Mr. Julius Aiwo, both highly respected professionals with deep experience in governance, risk, restructuring, and insolvency practice. Mr. Andrew Akoto is the country managing partner of KPMG Ghana, with nearly 3 decades of experience, and has previously served as partner and head of advisory, leading KPMG's risk consulting practice across several critical sectors. He is widely recognized for his leadership in governance, professional integrity, and institutional resilience. He is joined by Mr. Julius Aibo, a partner in forensic advisory at KPMG Ghana, with over 14 years experience spanning audits, technical accounting, restructuring and strategy and operations, and forensic advisory service across multiple African markets. Julius has actively contributed to receiverships, liquidations, and professional capacity building, and has been a regular speaker at CIRIP's organized conferences and workshops. Today, they bring strong practical insights and depth into today's presentation. So it tells you that we are blessed with such a high-profile resources to do justice to this critical code of ethics that should govern our operations as professionals, as CIRIP members, as IPs. So without much ado, I will invite our keynote speakers to take over the mantle and do justice. Thank you very much.
Okay, so thank you very much, Katrina and George. We really appreciate the opportunity to engage with the members of our August fraternity in discussing such an important topic. Given the context that you provided, it leaves no one in doubt the importance of really delving into this matter, because the work of insolvency practitioners is at the complex intersection of certain competing interests, be it from creditors, debtors, bankers, lawyers, insurers, and what have you, all in the ecosystem of helping to rescue businesses and put them on a path of sustainable recovery, and thereby to deepen our own economic transformation agenda. I note that the CIRIP Code of Ethics and Business Conduct was premised on benchmarking with that of other reputable professional bodies, such as that of the accountants, the bankers, and the rest. Interestingly, about 3 years ago, KPMG decided to do some sort of a survey regarding the effectiveness of the Code of Ethics and Business Conduct of the Chartered Institute of Bankers. And the outcomes of that survey were quite interesting, because whereas across the banking industry, we got very enthusiastic responses across, practitioners, or if you like, members within the banking sector. It was found out that close to 80% of our respondents were not even members of the Chartered Institute of Bankers. And for that matter, all the work done to put in place a very good code of ethics that would have ensured professionalism, integrity, confidentiality, and ultimately trust and accountability in this sensitive work that we do was lost, because if they are not members, then you are not going to also be able to hold them to that higher standard. Thankfully, with the CIRIP, which enjoins all insolvency practitioners to work with a code of ethics and conduct, it behaves on all of us more familiar with the code, and to ensure that we live its tenets on a day-to-day, thereby building trust and helping prosecute the objectives of the whole interventions that have been introduced as a result of the Corporate Insolvency and Restructuring Acts and also the CIRIP. Admittedly, I would have wished to have stayed throughout this program, but unfortunately, there are some competing demands. And so rightfully, my colleague Julius Ayibo will be taking over from here. Hopefully, we can carry on with this conversation and make CIRA and CIRIP work for all of us and for our stakeholders. Thank you very much.
Okay, so thank you very much, Andy, for those introductory remarks. So just I am sure that you can hear me. Can you maybe give me a thumbs up? I want to be sure that I can be heard. Can you please give me a thumbs up if you can hear me? Okay, because I'm presenting my screen, I'm not too sure if I can even see the responses that are coming through. But thank you so much, CIRIP, for this honor that you've done us to really be part of this very important conversation. So the topic that we are taking today is on what CIRIP describes as the CIRIP standard. The CIRIP standard. Ethics as the ultimate risk management tool in restructuring and insolvency in Ghana. Ethics today has to move beyond compliance and reposition it to the primary tool that manages risks, within the practice. So when we talk about ethics, I'm not too sure it's a new principle to anyone on the call. We are professionals in our own right, from being lawyers to chartered accountants to chartered bankers and so on and so forth. So the word ethics is not new. It's something that you eat and drink every day. I can dare say that it's a bread and butter for you on the call. It's about doing what is right, even if no one is watching. Doing what is right, even if no one is watching. And that has to, form a critical part of you as an insolvency practitioner. Whether or not you are an IP or just a member of CIRIP, this has to serve as a core of the way you operate, either in your practice or when you are assigned a responsibility, to provide support for a liquidation or an insolvency engagement. My agenda for the presentation today will look at 4 key areas. So I've already provided some bit of context, and Andy had already done that as well. I'll now delve then into what the CIRIP standard is. When we say the CIRIP standard, what does that mean? I'll look at ethics in practice, discipline and accountability, and I'll provide some closing remarks. Please feel free, add your comments. The chat box is open. You can make your contribution. The chat box, ask questions. Unfortunately, I cannot see from here, but I'm sure Petrina is on the call. She will draw my attention to it if you ask a question. Let me first of all start with, 2 stories that I chanced on, while preparing for this very important conversation. About 2 years ago in India, there was this insolvency practitioner called Amit Gupta. And as part of his work, he was, alleged to have undervalued assets that were under his purview, that were under his control, as part of the liquidation of a company that is called Provoke India Limited. So the former managing director of Provoke, filed a complaint that led to a police investigation. which found that, there were some merits in the allegations that were leveled against this very important and revered insolvency practitioner. So think about it. You're an IP, you've been given an assignment to do, and then there is an allegation that says that you have undervalued assets that you're supposed to be realizing for the benefit of the stakeholders that you're supposed to represent, like creditors. If investigation is done and it comes out that truly you've actually undervalued assets, for whatever reason, and there are so many reasons why someone would want to undervalue an asset. Probably you would want to sell the assets to a crony, a family member, or even get it sold to himself through a third party. That is the interpretation that anyone would give to such a situation. This is an ethical issue if found to be true. I also chanced on another story, about a liquidator being accused of withholding a series of court documents, from some defendants that was before the court. And that liquidator also misled the court in some of the averments that were made in respect of the case, and facilitated the misappropriation of a whopping 320,000 pounds. Look at that. An IP that is supposed to be an example, facilitating the misappropriation of 320,000 pounds. That cannot be the story of any IP on this call or any member of CIRIP on this call when given the opportunity to execute an engagement as important as either a liquidation or an administration. When ethics fails, values collapse. I want to make that point again. When ethics fail, values collapse. When we talk about risk do not start with numbers. Risk do not start with numbers. They start with conduct. When the conduct is right, risks get mitigated. But the conduct is wrong, risks get escalated. I decided to raise these two, ethics matters that I chanced upon because I want you to draw your attention to the practicalities of some of these issues, and then the effects it can have on you as an IP that is entrusted, with the responsibility of realizing assets to settle liabilities. That is entrusted with the responsibility of trust, fiduciary, to ensure that the stakeholders that look up to you to derive value are not disappointed. Let me take a few steps back to look at the insolvency landscape in Ghana. And I'm sure you're all aware that Ghana has made very significant strides when it comes to insolvency, with the passing of Act 1015 and the passing in recent times of Act 1117, the law that governs the conduct of insolvency practitioners in Ghana. And for me, for where I sit, it's a very progressive, shift from where we've come from a liquidation-driven framework to one that focuses on business rescue, how to preserve value, and that ultimately results in economic stability for all, and ensuring that IPs are well trained and that they can master the art to help businesses navigate the challenges that they face. So we moved from liquidation driven to business rescue. That is no news to anyone. So that's my first point. Now, the second one I would like to draw on is the code of ethics. I'm not sure how many of us on the call know that CIRIP has a code of ethics that it requires its members to abide or to comply by. You know, the CIRIP's code of ethics is supposed to be like your daily Bible that helps guide your behavior as an insolvency practitioner. And of course, when you do things outside of the code of ethics, there are sanctions. We'll go into the details of that. So it's very important for you to be aware. If you don't have a copy of it, Petrina just mentioned that it's on their website. It's on the website of CIRIP. You can go there and download it. Let it be your daily, Bible that you can refer to at any point in time. The third point I would like to touch on is professionalism through CIRIP. Professionalism. And when we talk about professionalism, what does it mean? The law requires professional conduct from every member of CIRIP, and the code also requires same from every member of CIRIP. We'll go through the principles just for you to get a sense of what the key principles are from the code of ethics, standpoint. Ethical conduct as a statutory expectation and not a discretion. So it's not a discretionary thing for you to be ethical. You don't have a choice. It is enshrined in the law that every IP, is ethical in their conduct, both during the execution of an insolvency engagement and even outside of that. So it is, your ethical conduct is not just, relevant when you are undertaking an insolvency assignment. But outside of that, that same level of standard is required even at home, because you don't take off the IP hat in the office and then do something else outside the office. So that standard is required across, because you are a professional that has to demonstrate the values, even in your personal arrangements, because you can just imagine if it comes on the front page of the daily newspaper that a CIRIP member duped someone of $10,000 in relation to a property that he was supposed to sell to the person. It's a personal transaction, but it still has the tendency of affecting you as a professional licensed to operate as an IP within our ecosystem. Now, ethics in insolvency practice. Traditionally, we have seen ethics to be viewed as a set of rules that professionals are expected to follow. So you are not supposed to do A, you are not supposed to do B, you are supposed to do C, you are not supposed to do D. But when you look at the way the code of ethics has been framed, it has been more reactive than proactive, because the rules have been set and you are just required to follow them. It's been more compliance driven, more compliance driven, right? And if you look at that, you realize that the impact is minimal. The impact is minimal. What we are looking at the moment, is under the CIRIP standard, is to say ethics as a system. Ethics as a system. And when we say ethics as a system, what does it mean? It means that it has to be a part and parcel of you as an individual professional. These are not rules that you're just following. These are not laws that you're just following, but they are principles that you've imbibed in yourself, that you demonstrate in your daily activities as a professional licensed by the body. It's not supposed to be reactive, but there must be a lot of proactivity and preventativeness when you're looking at the concept of ethics. So you're taking steps to prevent, as opposed to it happening and then you reacting, to it. Under the traditional approach, we have looked at, we have always looked at ethics as dependent on external enforcement. So which means that if there's no punishment, then we are not going to be ethical. If there is no repercussion, there are no sanctions, then we probably may decide not to be ethical in our dealings. Under the CIRIP standard, ethics depends on internal discipline. I've already alluded to that in my initial conversation, to say that it has to be a part and parcel of you. You have to demonstrate it daily, so that you're not just demonstrating that within a context of a professional engagement that you're executing, but even outside of that, it is very clear to everyone that you are an ethical individual working for a very renowned a professional body as CIRIP. So whereas the traditional view of ethics has been, as I said, rules-based, reactive, and dependent on external enforcement, under the CIRIP standard, the CIRIP's definition, the CIRIP's system of ethics, we are looking at it being a part and parcel of you as a member. It should be a part of your fiber as an individual. It needs to be preventive. So you are taking steps to avoid incidences of, for instance, fraud, incidences of collusion. You are very much aware. There's a lot of self-awareness on a daily basis when it comes to the principles that are supposed to guide you as a professional. Then the discipline part comes in. We are all, on a daily basis, faced with our challenges, where our ethical principles are brought into question. But that discipline of ensuring that you do what is right must always, on a daily basis and all the time, be rife in your dealings, as a professional. So ethics is not merely compliance or a set of rules, it is a system of control. So we have gone beyond compliance, it's where we're checking, boxes, to say that we are putting a system of control that mitigates or that prevents, the occurrence of what, ethical issues. My next point is now delving into the CIRIP standard itself, the CIRIP standard when it comes to ethics. What does the CIRIP standard, say? First of all, I want to start with some of the key risks that you face as an insolvency practitioner. The first is on legal risks. As an IP, that is given a mandate to execute an insolvency assignment, I dare say your greatest risk is legal risk. So this may include a risk of litigation, regulatory breaches, sanctions. You would agree with me that when it comes to insolvency, it's also very heavy on law, and the need to be compliant with specific requirements of the law becomes very important. Ethical failures, such as conflicts of interest, lack of independence, non-compliance with statutory duties, can quickly result in legal challenges or enforcement actions against you as a practitioner. So when you are appointed as a liquidator, for instance, you may not be a lawyer, but you need a lawyer on your team that should be guiding you to ensure that you are abiding by timelines, you are abiding by requirements, you are abiding by things that you have to do when you are making a decision. Your decision has to take into consider the legal ramification of that step you are taking, so you don't expose yourself to that. So these are risks that you face as a profession. The second one I would like to talk about is when you start delving into the actual execution from an operational standpoint. There's an operational risk that you face, and that operational risk often stems from mismanagement, poor judgment, inadequate controls. You'll be faced with a decision, regarding a particular matter as you prosecute your agenda as a liquidator. And that would require serious professional judgment, your ability to question issues. So for instance, as an IP who is undertaking, let's say, a liquidation assignment, recoveries become a very critical part of your work because you're supposed to recover or realize assets to settle creditors or liabilities. You have a debt of a certain sum on your books. There's a security whose value fully perfected, is more than the debt that you're trying to recover from a debtor. But you end up recovering far less than the face value of the debt. While there's a security that you could have realized, to pay off fully the amount that is owed. There is no way you would be able to justify to anyone that you decided to release the security and then recover just 50% of the debt. Of course, I know the intricacies may be a bit more different than I've just described it, but I'm just painting a picture for you to understand some of the risks from an operational standpoint that you face as an IP, and the need to ensure utmost quality judgment when you are making such very important decisions. The third is reputational risk. As an IP, one of the critical risks you face is your reputation. You don't want people to lose trust in you. Once trust is lost, once you lose your stakeholders, and you have different stakeholders from creditors to debtors to the courts to the regulators to the wider public, especially where the liquidation is a public interest type liquidation. When you lose trust, in the people that put you there, it puts the entire exercise, in jeopardy. And this could revolve around things like, your professional standing, and it could affect, future appointments. If you don't want the tap to income to be closed, then you have to look at this risk very, very seriously. The last one I'd like to touch on is financial risk, value erosion. Ethical lapses can lead to value erosion. And how do you facilitate as an IP value erosion through allowing lapses in ethics? Will lead to increased costs, delays, liquidation expenses. You could even result in significantly low recoveries when you're supposed to be doing more recoveries, because there have been some ethical lapses. Recoveries become low. Let me give you an example, a practical example. So you are a liquidator. Has a responsibility of recovering from company A that owes a certain sum, right? If your ethics is not up to scratch, the tendency for someone, that data walking into your office and offering you a kickback in order for you to reduce the amount he owes is very high. If you fell for that pressure, what happens? Yes, you'll be enriching yourself as an IP, but the interest of your stakeholders, become jeopardized. You lose the amount that you actually are supposed to recover in order to settle your creditors, just because you've looked at your parochial individual interest. These are three very important risks that you have to apprise yourself with as an insolvency practitioner: legal risks, operational risks, reputational risks, financial risks. And all these risks have a connection with how you play with ethics, standards, professionalism. If you don't do what is right, people can sue you. That's where the legal risk is. If you don't do what is right, if you mismanage, you erode value. Your reputation can be at risk when you are found. And of course, the recoveries that you're supposed to be making and the payout that you're supposed to be making to people like creditors significantly reduce. Every one of these risks is triggered by ethical failure. I don't have to belabor that point. Every one of these risks is triggered by ethical failure. Where ethics fails, these risks are heightened. But where ethics is significantly and seriously at play, these risks are mitigated. So there is what? There is some kind of a correlation between them, negative or positive. I think it's a negative correlation. If your ethics is so positive, negative. If your ethics is low, the risk goes high. If your ethics is high, the risk comes down. So that negative correlation, exists. So what are some of the fundamental principles as risk control mechanisms? Now I'm now delving before I even can. I'm now delving into what the CIRIP Code of Ethics says. It has 5 fundamental principles. They are not supposed to be abstract ideas. They're supposed to be practical controls that help manage and reduce the risks inherent in insolvency engagements, where professional judgment, discretion, public confidence are non-negotiable. So there was a lot of thinking that went into the development of these very important 5 principles that are espoused in CIRIP's Code of Ethics. I'll take them one after the other. The first one is professionalism. Professionalism. How does professionalism function? It functions as a control against incompetence and mismanagement. Not everyone can be an insolvency practitioner. If you are incompetent, you cannot perform such an exercise. The code mandates professionalism in your execution, in the execution of any mandate that you are given, that is given to you as an insolvency practitioner. So by ensuring that you maintain the necessary skills, experience, diligence, professionalism supports sound decision-making and effective administration of insolvency cases. It's very important. Ask around if you have not really undertaken any insolvency work before. The diligence that is required, the attention to detail that is required, the sense of responsibility that is required. You cannot but remain professional as an IP. What does it do? What does professionalism do? It reduces risks of errors, poor outcomes, and criticisms. If you have a great eye for detail, there is nothing that will slip by. It ensures that you are delivering value for the people that put you there. So professionalism prevents incompetence and mismanagement. The second one is independence and objectivity. It manages conflict of interest. Conflict of interest is always a serious matter that is raised usually during insolvency, assignments. As an insolvency practitioner, you cannot put yourself in a conflict of interest position that clouds your judgment, that affects the way you look at things, that affects how you are supposed to perceive, assess, and deliver on the mandate that you have been given. It's essential, independence and objective is essential for managers as a conflict of interest. And as a practitioner, you are supposed to act impartially, free from undue influence, whether from creditors, shareholders, and other interested parties. When you uphold independence, it ensures that your decisions are made solely in accordance with your duties, your statutory duties as enshrined in law, or in whatever engagement letter you've been given, and the best interest of the process is not jeopardized. What does it do? It helps maintain and protect the credibility of the process. So when you are an IP, and you have to realize an asset, you cannot sell that asset to your wife. You cannot sell that asset to your friend. You cannot sell that asset to yourself. Even if you decide to sell the asset to yourself at market value, nobody will believe you, because it is just not right. That is a conflict of interest situation. It is just not right. You can't buy yourself. Your son can't buy. Your wife can't buy from you as a liquidator or an insolvency practitioner when you are executing an engagement, because it avoids what? A conflict of interest situation. The third is confidentiality. When you are an insolvency practitioner assigned with a responsibility, you become open to critical and sensitive information that you have a responsibility to protect. You have access to commercially sensitive, personal, and strategic information sometimes, and how you deal with this type of information tells a lot about your ability to hold and trust critical assets that are given to you, critical assets that you have responsibility for. Maintaining confidentiality protects stakeholders, preserves confidence in the practitioner, and reduces the risk of misuse of information. And of course, I've already spoken about reputational damage, that may arise from inappropriate disclosures. In fact, you could even be sued. So the risk of litigation even gets heightened if you don't maintain confidentiality in the work you do. The fourth one is integrity, the elephant in the room. Integrity reduces fraud, dishonesty, and misleading conduct. This is a very, very important value or principle that you must espouse as an insolvency practitioner. If you are not one with integrity, you cannot be an IP. Fraud is reduced when you have integrity. Dishonesty is reduced when you have integrity. Misleading conduct is reduced when you have integrity. As an IP, you'll be faced with serious, dilemmas on a daily basis as you execute your engagement. People coming to offer you money will be rife. So just imagine you, an IP, doing a liquidation assignment. Someone owes you 10 million Ghana cedis, owes the company that you're liquidating or whatever, or that you're serving as administrator for 10 million Ghana cedi. And the person comes and says, I'll pay you 5 million, and then I'll pay the company 5 million, and I give you 1 million. So in total, you're just recovering just 6 million from the person. Technically, 1 million is going into your pocket, and the rest of the 5 million going into the company's coffers. 1 million is a lot of money. It is a lot of money. But the question is, would you bow for that pressure? Would you hold in high esteem the responsibility and the mandate that has been given to you to protect the interests of the many stakeholders that you represent in that very important position? When you have integrity, no amount of money can shake or move your position, because you always have the interests of the many stakeholders that you represent at heart. Integrity is doing what is right, even if no one is watching. Doing what is utmostly right, even if no one is watching. And it underpins public confidence in this very important regime that we have set for ourselves, that we have accepted that we need to prosecute going forward. And it ensures that actions and communications can withstand scrutiny from the courts, regulators, and stakeholders. Integrity cannot be underestimated. The last one is practice management. Practice management. When we talk about practice management, what are we talking about? Control, record keeping, accountability. So when it comes to managing the entire, insolvency assignment, or even managing your practice as an insolvency practitioner, this principle has to guide the way you go about things. Because you know that to remain accountable, you must keep accurate records of the activities that you undertake as an insolvency practitioner, because it would be audited. You must put yourself up for audit at the end of what? The process. If you don't keep good records, how do you, achieve that? Effective systems, documentation, oversight, and governance within the insolvency practice help ensure ethical standards are consistently applied. Practice management also supports what I will call compliance. It facilitates review and provides clear evidence that the decisions that you took as an insolvency practitioner were made responsibly and in accordance with professional obligations. So you're not just taking decisions, anyhow, but the decisions that you're taking are based on facts, are based on evidence, are based on information that if a third party comes and that same information is availed to that third party, he will come to almost the same conclusion as you. That is why it's important to ensure proper governance in your practice as an insolvency practitioner. So these are five critical principles that are enshrined in our code of conduct. Let me just rehash them again. Professionalism, independence, and objectivity. It helps avoid conflicts of interest. Confidentiality. You will be faced or exposed to critical information that you must protect as an insolvency practitioner. Integrity. Do what is right, even if no one is watching. And practice management. It strengthens your control, records keeping, and accountability, because your work will be checked. Your work will be examined. Your work will be tested. And when it is examined, checked, and tested, the outcome must not differ significantly from the outcome that you came to. Okay, I don't know whether there are any questions or contributions in the chat. Petrina, are you able to draw my attention to whether there's anything happening in the chat, because I can't see the chat where I am at the moment.
Julius,
can I proceed?
Yeah, you can proceed. There are no questions yet. Anytime
Okay.
it drops, I'll let you know, please. Thank you.
Okay, thank you so much. It's supposed to be this session is supposed to be an engagement, so I'm sure maybe we'll have a session at the end of the process that enables people to also share their experiences, share their ideas on this very important topic. So let's look at ethics in practice. Ethics in practice. So ethical governance in insolvency applies throughout the entire life cycle of your engagement. It begins from the appointment phase. So from the day you are appointed as an insolvency as an insolvency practitioner to execute any engagement or any assignment, ethical governance starts from that stage. So at this stage, it requires or ensures that you achieve legitimacy and suitability as a practitioner. Let me give an example. Let's say you are appointed as an administrator of of a mine, for instance, of a mine, of a very big mine. And as an administrator, probably you've just done about one and a half years. The question you should be asking yourself is that with this scale, with this assignment and its scale and complexity, do you have the experience, expertise to be able to run a mine? If you don't, probably nothing stops you from declining and recommending someone that has the experience. So when it comes to assessing your capacity and your competence at this appointment phase, the responsibility behoves on you. It is ethical to say, I don't have capacity or expertise to manage or to deliver on this very critical assignment. It's very ethical to do that. If you take it on and you fail, it is unethical. You have a responsibility to notify regulators, from GRA to the Office of the Registrar of Companies. Yes, some will say GRA is not a regulator, but of course, when you go into at 896, you have a responsibility, to notify them when a company goes into liquidation or that, because they need to come and do their tax audits and then recover their taxes. So there's some responsibility there. It is ethical to say, oh, I'm conflicted because I've ever served as A or B for this company. So appointing me as an administrator or as a liquidator, puts me in a conflict of interest situation. Disclosure is key. So right from the appointment phase, you are faced with some ethical responsibilities that you need to get by. Number two, when you get into the actual execution, what are some of the considerations that you have to look at? So on your day-to-day execution of the assignment, what are some of the things you have to look at? So for instance, when you go into section 16 of Act 1015, it says that within 21 days after a company is placed in administration or administration commences, the administrator has a responsibility to investigate the affairs of the company and form an opinion on whether the company should execute a restructuring agreement, the administration should end, or the company should be placed in liquidation. The question is, faced with the facts, is a rescue a viable option? Are you making that decision because of A or B? Is your decision centered on facts, information that has become available to you? Or you are making a decision because you have a personal interest in there? Fair treatment of creditors. Are you allowing other creditors that are the loudest to sway your decision, to sway the direction you go? Or you are giving equal opportunity to everybody because they are all equal stakeholders within the ecosystem? Are you maximizing value when it comes to recoveries? Or you are doing deals on the side and minimizing recovery value for shareholder? I've given a number of those instances, and I said that as an insolvency practitioner, you are going to be faced with those challenges. People will come with money and say, take this one, let me pay this one. Are you going to accept that? Are you going to maintain transparency with regulators, transparency with creditors, transparency with debtors, transparency with other key stakeholders, to ensure that whatever you are doing, they can all see it black and white? Or are you hiding information from them because you don't want them to test or put to a test the judgment that you've applied in making those decisions? or the processes that you applied in making those decisions. Next is the estate management phase. Estate management is where we're talking about assets. And this is always a very critical part of any assignment, because basically, as an insolvency practitioner, you deal with what? Assets. You deal with liabilities. In your disposal of assets, what are the considerations? How do you dispose? Do you do that by public, auction, or do you do private sale? Okay, if you're doing private sale, how are you negotiating the sale? Are you negotiating hard to ensure that whatever you are recovering can help the stakeholders that you're representing? Or you are just doing business as usual? As my boss Amano will say, or are you selling the assets as if you are selling tomatoes? Or you are placing premium on the things that you're supposed to, once they have value? You may not have expertise in a lot of the areas, so you may have to engage experts. So if it's a valuer, you need to bring a valuer in to look at the values to ascertain whether the value at which you want to sell is market value, the for sale value, all those things. Do you need a legal opinion? Do you need an accountant to do some assessment to ascertain what number it should be? The expenses that you incur in the process of realization, are they reasonable? Or do you have people just behind, charging ridiculous expenses and eroding value for the stakeholders that you're supposed to work for? So at the estate management phase, ethical governance plays a very critical role. And note that you may be ethical as an insolvency practitioner, but you may be surrounded by others whose ethics is not as strong as you. That is why you need to make sure that you have a serious and a strong governance around how these things are done. So before a decision on a recovery is made, is there a committee that must sit on it and discuss it? After the committee sits on it, is it escalated to another level if the amount involved, it falls outside of a certain threshold? These are things that you can look at to ensure that the decisions you're making around how you manage the estate of the company are the best and will achieve the objectives of the assignment. Now, when it comes to termination and close out, sometimes you may have to make an ethical decision to resign from your responsibility as an IP when certain things happen that infringe on your principles. You must properly hand over when you are done. You cannot just, execute an assignment, pack your bag, and then move on. No, there's a process that ensures, you must make sure you're going to the process that ensures that everything is done and done to the letter. And you are preparing reports on an ongoing basis, and you are preparing reports at the end of the period to account for your stewardship. And of course, audits are always a critical part of the process. So when you are done, someone else must come and check whether what you have done during the course of the assignment is consistent with what you're supposed to do. The numbers you're reporting, are the numbers accurate? Are they complete? It has to be checked and signed off by a qualified accountant. And of course, even at the end of the process, you still have to continue to maintain confidentiality, because those obligations do not curtail at the end of the process. It still subsists. You can't disclose information that came to your attention if you are not supposed to do so. Now, let me touch on insolvency practitioner as a risk manager. Petrina, I just want to be sure. Am I doing well with time? How many minutes more do I have?
So you have about 15 minutes, let me say.
15 minutes, okay. So let's look at an insolvency practitioner as a risk manager. You know, I spoke at the beginning about some of the 4 risks that an insolvency practitioner faces. Ethical risks, financial risks, and so on and so forth. I mentioned those. So you are not just managing a process. I want you to remember that you are not just managing a process. You are managing risks across multiple stakeholders. And these multiple stakeholders have competing interests. Their interests are never aligned. Their interests are always competing. Stakeholder A, creditor wants to go left. Stakeholder B, debtor wants to go right. So you have to manage all these risks. What does that make you? It fundamentally makes you a risk manager. So risk management must be your bread and butter. Risk management must be your a daily resolve. You can never look at anything without looking at it from a risk management perspective. So if you are making a decision, what are the risks? If I'm appointing valuer A, what are the risks? If the risks are within manageable limits, proceed. If they are not within manageable limits, are there any mitigation steps that you can take? If there are no mitigation steps that are available to take, move to decision B. So in this capacity, as an IP, you act in a fiduciary to all stakeholders. You owe them duties not only you owe duties not only to a single creditor, for instance, or an appointing party, but to a collective body of our stakeholders, which affects the integrity of the entire process. So you have, as I said, competing interests in so many stakeholders that you have to manage, and you have to satisfy each competing need. It's a position of trust that you have been given. Please do not forget. If you forget anything, don't forget this, that when you are appointed an IP, a liquidator or an administrator or a private liquidator, you are in a position of trust. So it requires you to act fairly, impartially, in accordance with statutory and ethical obligations. And this ensures that you maintain a balance that satisfies the needs of each of the interests that you represent, which are always what? Competing. 2, central risk manager. Throughout an engagement, there's risk management at every stage. It involves identifying all the risks, legal, operational, reputational, financial, asking yourself whether there are whether those risks are within manageable limits. If they're not within manageable limits, are there any mitigation steps that you need to take to put them within manageable limits? If there are no mitigation steps, you may have to take a different turn, because sometimes risk can be can be at levels that cannot be managed. Finally, is the professional being personally accountable. Personally accountable. Don't forget, if you are a liquidator, an administrator, liabilities are personal. It is not abstract. It attaches directly to you as a practitioner. It attaches to you directly as a practitioner. So you cannot afford to expose yourself significantly like that. That is why you need advice, expertise, you need experience to handle some of these critical assignments. They are not business as usual type assignments. The quality of your ethics determines the quality of the outcome. What are some of the practical challenges that insolvency practitioners face when it comes to ethics? There are practical. The first is pressure from creditors. In my initial remarks, I'm sure I've mentioned them a few times. Creditors always seek preferential treatment. They want faster recoveries. They want decisions that are made that satisfy individual interests. They never look at the collective. And as a practitioner, you have a responsibility to manage this pressure, and that requires you to remain impartial and to act in the interest of the creditor body as opposed to just an individual creditor that has a particular interest that he or she wants to manifest or to prosecute. And sometimes you have creditors in a group that are very influential. So if you don't sometimes put your feet on the ground, they can sway you to a direction that you don't want to go. But always remember that when you're faced with pressure, your decisions have to ensure that you are achieving an outcome that satisfies the collective and not just the individual. Second is debtors. Debtors can wield very serious influences. They may attempt to shape the outcomes through persuasion, selective disclosure of information, informal relationships. They want to be best of friends with you. They owe you money and they want to be your friend. How? You cannot be best friends with a debtor as a practitioner. The one you're supposed to be collecting money from, you are his best friend. How? He's not going to pay you. You can't be visiting him in his house and be eating fufu and abenkwine every Saturday. You can't do that because you have money to collect. You have assets to realize. Why is that? Because it can influence your decisions. Asset realization, disclosures. It creates a risk of compromise and creates a situation where you are not able to get past that relationship that you've built, which places the entire process in jeopardy. So, of course, what is it be hostile? I'm not saying be hostile, but make sure your relationship is professional because you have a business to execute. You have money to collect. Third is political and relational pressure. Someone once said that almost everyone in Ghana knows everyone because Ghana is a big compound house. Yes, we all know that. But you still have a responsibility to play. You still have a responsibility to a duty to execute. IPs usually they will face political pressure. They will face pressure because they know somebody that they have to deal with aggressively or they have to deal with not friendly. Especially when you have situations where the liquidation or the assignment or the insolvency assignment is a very high profile public interest one. We have seen that in many cases across, especially an example would be the banks that have gone down and some of the issues that have come up to those processes and the kind of stakeholders within that space that have to be dealt with. Such pressures undermine transparency and fairness if the practitioner feels compelled to accommodate external interest. My fourth is time constraints. There is never enough time for any insolvency assignment. Time is always of the essence. For instance, as an administrator, 21 days after being appointed, You must make a decision whether or not to proceed, whether the company has to be placed in liquidation, whether to prepare the restructuring agreement. You need to organize a watershed meeting. That watershed, there are just so many things that have to be done within a short period of time. There is never a time. This poses practical challenges to IPs. You need to make urgent decisions, and sometimes those urgent decisions, you don't even have a complete information to use for those decisions. How do you get around that? Speed is always of the essence, because if you don't move with speed, you're not able to preserve value. Time constraints can heighten the risk of errors. Ethical lapses may happen without you knowing it, because the judgment that you need to apply, the rigor that you need to apply, becomes limited because you don't have the time. So these are some of the risks. I'm sure you would have more, right? That you need to be apprised with. Discipline and accountability would be my last section. Ethical breaches by insolvency practitioners attract real disciplinary consequences. It's a serious matter. If you breach a principle, the law prescribes sanctions, and I will look at some of them. There is a disciplinary committee when you look at the law that is supposed to go into any reports of misconduct against IPs. They have a responsibility to ensure you are heard, and they will make a decision whether or not the allegations that have been made against you are meritable. It ensures that if there are any alleged ethical failures, they are examined fairly and transparently, and while ensuring that appropriate remedies are made available so that these also are not breached. I've already spoken about the fact that the Act provides for sanctions, including revocation and suspension. So your license could be revoked, you could be suspended, and so on and so forth. And it's just a lot that you can face as an IP if you are not disciplined, if you are not accountable, if you don't go by the code of ethics. So I have a this in here that it is not, the standard is not merely aspirational. It is backed by a disciplinary framework that reinforces accountability and protects the integrity of the insolvency practice. We have a practice to protect, and therefore we must ensure that everyone is aligned. Everyone is doing what is right. Everyone is living the values that we espouse, the principles that we espouse for ourselves, because that is what would strengthen the practice, the insolvency practice in Ghana. That's what will ensure that people have confidence in it. That is what would cause people to businesses to open themselves up to you to help turn them around. What are some of the consequences of ethical failure? I've already mentioned them: revocation of license, suspension or revocation of membership, reprimand with or without a fine, reputational damage. There is none that is bigger than reputational damage. You will chop shame. You will chop shame if you breach any ethical conduct or principle. I'm intentionally saying it that way, you chop shame. If your license is revoked, the repercussions are dire. If you're suspended, the repercussions are dire. If you are slapped with a fine, that is money leaving your bank account. So as you go about your daily activities, it's important as an IP to be self-aware of some of the principles that are supposed to underpin the way you work, to ensure that you are not infringing on any code, any ethical requirement, any provision of the law. My closing remarks. Ethical leadership is at the core of any effective insolvency practice and underpins trust across the ecosystem. There's an entire value chain that needs to be protected, from lawyers to accountants to students, etc. And that protection only comes through ethical leadership. When practitioners constantly and consistently demonstrate ethical leadership, they help build and sustain trust among the various stakeholders, from creditors to investors to regulators. And trust is very essential. It's an important ingredient. I've mentioned that several times during this conversation. It's an important ingredient because once trust is lost, credibility is lost. It strengthens confidence in insolvency practice. Our practice is still very young. We are still trying to build. If we are still trying to build, this is when we need all hands on deck. IPs doing the right things, IPs complying with the principles that have been espoused in our codes of conduct, IPs doing executing their engagements properly, IPs identifying risks and mitigating them, and so on and so forth. It attracts others to the practice because they trust it and they have confidence in it. It promotes long-term confidence in business rescue outcomes. I will not belabor that point. It reinforces fairness and professional discipline and supports credibility of Ghana's insolvency regime. As I said, we are still very young and we have a lot of work to do as one body, and everyone has that responsibility to play. My closing thoughts. The effectiveness of Ghana's insolvency regime depends ultimately less on the strength of our laws or the laws that govern the practice, and more on conduct of those entrusted to apply them. I will not belabor the point that strong legal framework provides a structured approach to how we do our things as a practice. It gives a structure and authority. But it's important to note that it is the day-to-day decisions, the judgment, the behavior of insolvency practitioners that determines whether the regime operates fairly, credibly, and in the public interest. Ethical conduct, therefore, becomes the practical measure by which the system is assessed by all the stakeholders I've just mentioned, from creditors to regulators, and even to the wider public. It should not be viewed as a reactionary safeguard. Instead, it should function as a preventive system that guides decision making, manages the risks that I spoke about in my earlier presentation, and enforces accountability throughout the process. It requires that ethics is embedded. And when it is embedded, it serves as a core to professional discipline. It prevents misconduct, protects value, and sustains confidence in the outcomes that we all want to see. It also ensures that the regime achieve its intended process, its intended purpose of ensuring orderly resolution and business recovery. Ethics is key. We cannot overemphasize that. Let that be your daily bread and butter as an IP. Because when we ensure that we are ethical, when we invest in ethics, when we imbibe ethics, we are setting a trail for others to follow. We are ensuring that confidence in our practice is increased. And the stakeholders that require us to succeed can come to us when they need us. This cannot be overemphasized. I thank you for your attention. So
Wow.
I guess if you,
Yes,
okay, yeah, Petrina,
Julius.
please, you can go ahead.
Yes, I have taken over the mic. Thank you very much.
Okay, thank you.
That is
Thank
a
you so
very
much.
insightful presentation. Thank you to Mr. Akoto, even though he was unable to join us. He started with us, but he had to leave it over to you. And you've done a very great job. And as you have said, we should make ethics our daily bread and butter. I'm sure all of us take bread and butter every morning. So please, when you take your bread, you cut and you're going to put your butter in, please remember, Julius says we should take ethics and probably replace it with the bread and butter. Anyway, that's just an aside. So before I go on, please permit me to acknowledge some people. We have our immediate past Governing Council member, Professor Albert Fiajo, who is always supportive of this institute. Even if he's away, he makes sure that he joins every program we do when it's possible. We also have our Registrar of Companies, Mame Sama Prepra. We have the Deputy Registrar of the Office of the Registrar of Companies, Benjamin Zigosh. We have a few council members here. I mean, if I say council members, I'm referring to those we elected at the AGM because the council is not fully constituted now. So I have Gertrude Ama here, I have Kenneth Gate, and then Clara Amatefu here. So quickly, before we take the Q&A, I'd like to just give key highlights or a quick summary of the areas that Julius touched on in terms of the topics that we're discussing. He mentioned that when ethics fail, values collapse. He says ethics is not discretionary, but it is mandatory. And he says these ethical principles cut across our daily lives. It's not just in our professions. So in his presentation, he touched on the key risks in insolvency, and it included legal risk, operational risk, reputational risk, and financial risk, and said that all these risks are triggered by ethical failure. Then he went on to touch on the CIRIP Code of Ethics itself, the 5 fundamental principles, which are professionalism, independence and objectivity, confidentiality, integrity, and practice management. He also touched on ethical governance, where he talked about the various phases, that is the appointment phase, and talked about issues like notifying regulator, confirming licensing status, disclosure of conflict of interest, and so on. He talked about the operational phase also, and estate management phase, and the termination and closeout phase. And then he came to the IP as a risk manager, and then practical challenges, which included pressure from creditors, influence from debtors, political influence, and time constraints. And he came to talk about discipline and accountability. And finally, he ended with consequences of ethical failure. So if perchance your network went off or you're just joining us, I've just given you a summary of what Julius helped us. I think this presentation has been quite practical. And so it is time for us to be interactive at this time. Please, if you have a question, there is a hand raising feature on the call. Kindly raise your hand. I will call you and then you ask your question. Please feel free. We want to be very interactive. I saw a question, Julius. Somebody sent a question in the chat and said, auctioneer and IP, please compare and contrast. That is from Naomi Na Adole Seya, if I'm correct with the name. So Julius, please, I'd like you to take this up.
That sounds like an exams question. Auctioneer and IP, please compare and contrast. Okay, so you are an IP if you are licensed under the law, and the IP has key responsibilities. So if you're an IP if you can do work like being a liquidator, being a receiver, being an administrator, and so on and so forth. And also note that you cannot do insolvency work in Ghana if you are not licensed as an IP. Just as you cannot be a doctor if you are not licensed by the Ghana Medical Association, or a lawyer if you are not licensed by the Ghana Bar Association, or a chartered accountant in Ghana if you are not licensed by the Institute of Chartered Accountants. So an IP, has an extensive, a list of responsibilities when it comes to business rescue, in Ghana, from administration to liquidation. That's one auctioneer. An auctioneer is just one that is appointed to auction or to sell an asset, and usually auctioneers, support IPs, in their bid to realize, in their bid to realize, assets of the entities that they represent. So, for instance, a liquidator needs to sell a plant. That is one of the assets that he took over, or he assumed, as a liquidator. He doesn't know the value of the plant, right? So you get a valuer. That is also one of the key, aspects that IPs usually work, to value the plant. All right. Then in the actual sale, especially if you want to do public sale, you need an auctioneer, a licensed auctioneer, who would now come in with the experience, to sell the asset or to dispose of the asset by public auction. And there are specific rules that guide that. There's a law that guides how, public auctions, are done. So basically, I hope that I'll get some very good marks from Naomi in relation to the response, I just gave. So yeah, so basically that's what it is. It is Petrina and Naomi. I don't know whether I've addressed Naomi's questions, but of course, I believe that there are also very experienced people on the call. If anyone has any thoughts, they could also share on this question. Thank you.
Thank you, Julius. Naomi, if you are there, is your question very well answered? Is there any other person who wants to share more insights? I am still standing by for questions.
President, or contribution. We could also take contribution.
Okay.
Yeah, contribution. Practical insights into the topic. Will be very much welcome. They are very experienced people on the call, and that should be able to share some of their, some thoughts, on this very important, discussion that we just had, this afternoon.
I can see Godwill and Sir. Are you ready to talk, please? Okay, so anybody, any thoughts? Okay, Eunice Lamte says insightful presentation. Thank you, Eunice, for the feedback. Anybody wants to add their voice, please? No questions?
Katrina, I think Audrey wants to talk.
Okay, Audrey, please go ahead.
Audrey didn't raise her hand. But yes, it's been an incredibly insightful presentation. I think what I would like to stress is that most of these things that Julius has spoken about, they are there to protect us as insolvency practitioners. Many of us who actually are in practice have faced situations where we are in courts basically on a daily basis trying to defend the work that we are doing and the acts that we have taken in pursuance of that work. And a lot of the time, it's our ethics, it's our ability to defend what we have done, it's our ability to go by the rules and the ability to understand what the rules are and to make sure that we are utilizing them to get the best possible value for the creditors. That is our main line of defense. So I think it's important that we take these things very seriously and that we take the lessons that Julius has shared with us extremely seriously. Because at the end of the day, that is what will protect us as practitioners and will help us to be able to carry out our tasks with diligence and hopefully make the best out of any estates that we are given to administer over or to liquidate. So fantastic job, Julius. I've truly enjoyed it. And I look forward to hearing from you again. Thank you.
Audrey, thank you very much for your comment. I was also wondering, since the CEO has started pointing out people, will the ORC, will the Registrar of Companies like to share a word or two with us concerning this subject matter, please?
Yes. Hi, Katrina, can you hear me?
Yes, please, we can hear you, ma'am.
Okay, thank you so much for this opportunity. I think this has been a very insightful um, topic discussion. And thank you, Julius, for this. After having assumed office, I realized that majority of the insolvency cases that are coming up are going to the private liquidators. So this is an aspect that we need to take seriously. If anything would affect the terrain, it would come from the private liquidators. So we need to be very conscious of the code of ethics and try to abide by it. I think there's another thing that Julius did make mention of that I realized practitioners are not paying attention to. That is the reporting to the ORC. I think it's supposed to be a monthly reporting to the ORC on the liquidation that they have assumed control over. Now, what most practitioners do now is they inform us at the beginning, and then when it's over, they bring the report. But then there has to be that consistent reporting that would help us monitor what is going on, point out any issues that we may have There were a few issues raised by our office with some of the liquidation that went on last year, where we almost didn't accept the final reporting because um, there was this failure on the part of practitioners to report periodically to us on the liquidation that they were engaged in. So I think we need to pay attention to that. We also need, beyond that, we need to also keep our licenses alive. We need to make sure we update it regularly. I know majority of practitioners are also professionals in other fields like the DBA, with the ICAG and all that, and they renew their licenses from time to time. And given how this profession is a new one, and we want to keep it alive, we need to also be regular on that as well. I don't want to belabor the point, but I think Julius has said it all. And organizing things of this nature should be a regular thing just to keep us on our toes and to ensure that we are transparent and that all the work that we do is one that will lead to satisfaction to the client, because it will keep them coming back if we know that we are professional and we do what's best and needed for this profession. So thank you so much, and do have a lovely evening.
Thank you very much, Madam, for honoring this very short notice invitation to speak. I can see Dick Gordon's hand up. Dick, can you please unmute and ask your question? Thank you. I'm sorry, Dick, we cannot hear you, please.
Petrina.
Oh. Hello.
Petrina.
Hello.
Hello, yes, please.
Can you hear me?
Aha, I can hear you now.
Yeah, I think the speaker spoke more on a practical approach, but then he forgot to bring the modern thinking concept in ethics. Virtue ethics is a moral theory that focuses on a person's character rather than rules. If we focus on duty-based ethics, we end up having consequence, or what we call in virtue theory, consequentialism. And consequentialism doesn't really develop professionals. A moral good person is someone who develops and practices good character. So I think the institute have to focus on asking what kind of a person should the practitioner or insolvency practitioner be. And in answering that question, we should also focus on the key virtues and positive character traits, which is basically in honesty, courage, kindness, justice, and self-control. Most of our ethics, professional ethics, has been linked to the professional accountancy and the legal legal profession ethics. But as an IP, we need to have more a character that shows kindness in solving business owners' problem, because they are at the verge of losing all their assets or losing their life, what they've taken years to build. So we shouldn't be a rule-based character when it comes to doing our work, but then we should consistently show traits that consider us to be morally good. Thank you.
Thank you very much, Dick Gordon Annan. Julius, do you have something to say before I go to the next question?
No. So no further comments. Thank you, Dick, for that perspective. That is very much appreciated.
Okay, so let me quickly go to the chat and see what the Pabna Edukusi says. Brilliant presentation. Thank you, Julius. Indeed, we agree. Teresa Ampedu Boateng says, insightful. Thank you, Julius. And Emmanuel Hansen says, well done, Julius. This is clearly a masterclass session on the Code of Ethics, the CIRIP code. Okay, thank you, Emmanuel. And then Ni Adumensa says, please share the recording with us for reference. Ni, we will do that. Okay, don't worry. Now, Julius, I'm going to the next question from Charles Akwabua. He says, thank you, Julius, for that wonderful presentation. I want to find out if IPs can request for extension of time when they feel information gathered are not enough to take a decision about a company that is under administration. Julius, would you take that for us, please? Was the question clear?
So, Petrina, okay, so I want to find out if IPs can request for extension of time when they feel information gathered are not enough to take a decision about a company that is under this administration. But my question to Charles is, what kind of decision are you talking about? Can Charles be specific on the specific decision that he's talking about? Because the law does provide, for seeking an extension, but it's on various matters. So the answer to the question cannot be straightforward. So if we know what specific decision the extension is required for, that can put things in proper context, for a more direct and absolute response. Thank you.
Okay, so Charles, are you here to give us some further details about your question as Julius is asking?
Okay, I want to come in.
Okay, Nee, please do so.
Yes. So basically, I think so mostly, we need to assess whether to make a determination and meet the creditors, right? And mostly in assessing, you may have to see whether they have the audited financial statement. You have to see whether they have the blah, 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 whether they are keeping proper book of accounts, then start. But in most cases, some of them do not have proper book of accounts. So you need to reconstruct the book, ask the accountants to reconstruct the book to see whether, to enable you to assess, to do that assessment. So I'm sure his question is in that respect. Thank you.
Okay, thank you, Mr. Mensah. Thank you. Any further comments? I think Benis Agudu says, thank you, Julius, for sharing. Great presentation. Yes, Benis, I agree with you. So because we are working with time, I'll quickly go on to the next item. And at this point, I'd like to invite one of our
moderator.
Yes, please. Yes, please.
Please, maybe the question, I don't know whether if the question could be clarified. Whether the question could be answered.
Oh, you mean Charles Akwabua's question, right?
Yes, please. Yes, please.
We were okay. Okay, Julius, would you take it?
So is it in connection? Is the question? I'm still not very much. Maybe Audrey can help. I'm not too sure whether he's talking about in terms of the investigation.
Yeah,
I see Audrey's hand up. I'm still not very clear with the question.
Yeah, I think there are two positions where a practitioner would have to take a decision on a company that is in administration. The first would be at the watershed meeting, where the insolvency practitioner would have to decide or make an opinion as to whether the company is indeed a subject for administration. Now, the law does give a set amount of time. I've forgotten the number of days. But then the law also allows an insolvency practitioner to go to court to seek an extension of the time period that is stated in the Act. Now, the courts have the jurisdiction to give, I think there are two separate types of extensions. I've forgotten the exact number of days. So you would need to check in the act for that. So at that period, at that time, you can seek an extension from the courts to extend the legally mandated time so that it can give you more time to be able to get a better opinion as to whether or not you believe that the company is actually a target for administration or whether the decision has been wrongly made. So that is at the very beginning. Now, in the course of the administration, you may also get to the point where the creditors may decide that, well, they don't believe that the company is subject for administration anymore. As a practitioner, if you have information to the contrary, you can share it with them. Otherwise, at that point, it's the creditor's decision as to whether or not they want to continue or not. But at the very beginning, the law does allow the insolvency practitioner to get a court extension to determine whether or not the company is a target for administration or contrary. I hope that helps.
Thank you.
Yes, maybe let me just add a quick one. So in respect of, I think I heard Nick speak about preparation of financial statements, right? Where the law places the responsibility on directors of the company to prepare books of accounts or financial statements for the purposes of the administrator's work within 7 days. Within 7 days of that request or that appointment, I don't remember the exact decision, by 7 days. So the law requires, the law provides for an opportunity for the administrator to extend that timeline by an additional 7 days. All right. So that when you're an administrator, you come in, the books of accounts are not in proper order. But you need financial statement to start with, because you need that to be able to make decisions on the state of affairs and then the financial position of the company. If you request that by 7 days, the directors are supposed to provide with that information. If they are not able to do so, the law allows you to extend that by an additional 7 days. And so you have a total of a maximum of 14 days to be able to provide that information. So I don't know whether that provides an additional context regarding some of the timelines that the law provides for in relation to the provision of information.
Thank you.
Thank you.
All right. Thank you all very much for making this very interactive. As I said, we have some few minutes left. So, okay, so let me do this. Let me give the quick announcement. And then when we invite Clara to come and do the vote of thanks and she's done, she will close us out of here. So first of all, I would indulge all of you to look into the chat. I have just pasted a form there. Kindly fill it out for us. This is a form that indicates your willingness for this to be credited to you as a CPD. So if you fill the form, please fill it in the way that you want your certificate to be written. So how you want your name to be written in the certificate, that's what I mean. So kindly take 1 second out of your time. It's a very short form. It's not a long one that is requesting your next of kin and all that. It's a very short one. So please do well to fill it for us right now before we leave this platform. So as the announcement goes on, kindly fill the forms for us. So may I please have your attention for these few but important announcements. First of all, as I said, the CIRIP Code of Professional Conduct and Ethics can be found on our website. You can also send Emmanuel Hansen or any of us here hi with your request. We will send it to you. If you can also see, we have shared a lot of information on the platform. Please pardon us for invading your privacies and so on with information, but it is necessary for the growth of this institute. So we've shared the member data update form. We want to update our database. So kindly fill the form. Many people come to report that they don't receive invitation to events early or they don't receive it at all. Some say when we give any information on subscriptions they don't hear. So please fill this form for us so that you get accurate information and timely information also from us. So you can see again, we have shared members in good standing on our website. We have shared it on our platform, our social media platforms. Please take a minute from your busy schedule, go and check if your name is there. If you have paid up first and your name is not there, please alert Emmanuel Hansen. He will work on it. If you haven't paid, please do justice and then let us have your name there. As the law requires, we will be publishing it in the dailies, in the Daily Graphic and one other national newspaper. So please, we want you to make sure that everybody's name is here and then before we go and publish it in the dailies. We have an upcoming seminar on NPL. I know we've announced this for a long time. It's just a matter of modalities that has taken us a bit aback, but we will still do it. There are plans going on for us to have it. And then we said we will soon share information to you to contribute to the CIRIP quarterly newsletter. This quarter's own will come out very soon. And so we will ask all members to share any information that is newsworthy to be put in the CIRIP newsletter. So if you are in any organization, you've received promotion, there is any achievement, please do not hesitate to share with us. We will celebrate you very well. And any newsworthy information, any promotional activity from your organization, which you want us to promote it in the newsletter, please let us know. Last but the least, last and not the least, but very important information is that CIRIP is 20 years. Hooray! And this is our institute. This is how far the Lord has brought us. We have some activities lined up to celebrate this anniversary. Hopefully it will come off in October. So we'll communicate to you. Let us all come together and make this a very memorable anniversary. 20 years is not easy. So we will encourage all of you to give your best, give your commitment and everything that you can to make the anniversary celebrations successful. It will be climaxed with a dinner. So please get your dancing shoes and your dresses ready. Get your organizations ready to buy tables. And please make sure you buy them early, because if you don't come early, it will be filled up. We will not be able to get extra tables. Or we don't want you to sit outside and watch on the screen. We want you to be a part of the celebration. So please make sure you're not left out. At this point, I will invite one of our council members, Clara Amatefio Taylor, to give us the vote of thanks. Clara, I yield my mic.
Thank you very much, Petrina. Ladies and gentlemen, this has been an insightful webinar. As we bring it to a close, it's my pleasure to deliver the vote of thanks on behalf of the elected CIRIP Council members. Our appreciation goes to Mr. Andrew Akoto and Julius Aivo. Julius, thank you so much for your insightful contributions, all the comments in the chat and the different submissions that have been made attest to that fact. Like you said, the pressures that insolvency practitioners face are real, and our technical competence must always be anchored in integrity, independence, confidentiality, and accountability. To all our participants, thank you for your involvement, the questions you've asked, and above all, your commitment to continuous professional development. Your participation reinforces the importance of collective learning and dialogue in strengthening CIRIP. We're especially grateful to the CIRIP team, Petrina, and everyone in the CIRIP office, George. Because of your dedication and behind the scenes efforts, that is why this webinar was possible today. Your commitment to promoting restructuring and insolvency is appreciated. Today's discussions have reaffirmed that ethics, for IPs is not just a peripheral consideration, but the very foundation upon which creditor confidence, stakeholder trust, and the legitimacy of the insolvency framework is built. It is our hope that the insights so graciously shared by Julius will be used by all of us in driving ethical leadership in our respective practices. Once again, thank you all for your time and wishing you a very good evening. Please don't forget to fill the form that Petrina dropped in the chat. Thank you very much.
Thank you very much, Clara. Thank you so much, everybody. Clara has done the vote of thanks, so I'm not going to talk much, but I just want to say, Mr. Felix Hadu says hi to everyone. He extends his gratitude to you all for attending, though he was unable to join us, but he's there, right there in another event. So he's so grateful. I also want to thank all CIRIP staff, especially Emmanuel Hansen, for the hard work, and also for our CEO for his direction, and all other members for their contributions and their thoughts in making this event very successful. Good night, and you will hear more from us, please. Thank you.
Thank you.